two guys, for being with us. Let me explain just a little bit about what's going to happen. But first, let me ask you this. We did a robocall today, advertising the meeting tonight. I would like to ask, by a show of hands, who received a robocall at their home? Okay, all right. And let me ask you this. How many of you came at least in part because of that robocall? It's okay if not. Okay.
4.
Okay, as a reminder, good. Well, I appreciate that. You know, you never know if it works or not, and we like it actually when it picks up the answering machine and it leaves the message on the machine. That way it doesn't disturb the person, you know, because not everybody likes to get them. But anyway, thanks for letting us know that. Okay, so just to talk about what we're going to do this evening. In our forum tonight, the judges are very limited on what they can say. This is a nonpartisan race, and they set it up that way on purpose because if they were to state an opinion on some certain subject, then, and I don't know all the details of it, but that could disqualify them perhaps for serving or whatever it might be. So if you, at the end, are we going to have a question and answer at the end? I forgot to answer that.
If we have time, then we will have questions from the audience.
Yeah, so we will have questions, so just keep that in mind, that they may not be able to specifically answer what you're looking for. We'll just have to let them explain that when we get to the question, okay? So we have, what's going to happen is we're going to have 4 minutes. Each will introduce themselves for a maximum of 4 minutes, tell why you're running, whatever they want to do. And then each candidate will have 2 minutes for each question. And they don't have to take the whole time. And with the time left over, we will have questions from the audience, and they will have 2 minutes for closing, restating, clarifying, summing, whatever they want to do. 2 minutes to close with. They flipped a coin, or the coin has been flipped, and Judge Baldwin, are you going?
I lost.
You lost, so that means you're going first. So he's going to go first with his intro, then Brett Morton will go, and then we'll just alternate through the questions with who goes first. So, all right, so if you want to go ahead with your summary, your opening remarks.
All right.
All right.
I'm Thomas Baldwin. I was born in Oklahoma City, but have been in Ardmore since 1974. Graduated from high school here in 1980. My parents are Stan and Caroline Baldwin. We have Baldwin's Restaurant and Drive-In right around the corner. Worked there since about 1976, off and on my whole life. I've been a lawyer as of last September for 20 years. And I've been the special judge here in Carter County since November 2nd of 2009. So here in about 2.5 weeks, I'll have been the special judge for 5 years. I graduated from OU in 1991 for my undergraduate work. Went to OU for law school, graduated there in 1994. Hence, I've been a lawyer 20 years. That's how that all adds up for me. I have done a lot of different things as a lawyer. When I came back to town, I worked at a law firm. We did a lot of civil litigation, probates, wills, trust, estate planning. I did that for about 6.5 years. I went to First National Bank as a trust officer and was the legal counsel at First National Bank for 8 years, all the way up until the time I was appointed to be the special judge. During the time that I was at the bank and as a lawyer in a firm, I represented children, was appointed in deprived cases for just over 14 years. We also did all kinds of other civil litigation. When I got out of law school, in addition to that, I was about 6 months in the DA's office in Oklahoma County until I passed the bar and then came back to Ardmore. This is my hometown, my community. I really enjoy being a judge. It has given me some good experience, I think. Judge Card is our associate district judge, and he's retiring after 28 years. And I knew that if one of the judges retired, that after having some experience as a special judge, that I would run for the position, and that's why I'm doing that now. And I hope that I'll be able to continue, should I be blessed to be elected, to continue to be fair and impartial to the people that appear before me. I've had approximately 1,000 divorces that I've actually done for trials over the last 5 years. I've met about 9,000 people that I've had to read charges to. Of those 9,000, fortunately for some of the people, it's not 9,000 people total, it's about 7,000 people. Some of the people were busy, and so I've had to meet them on multiple occasions. But I hope to never forget that when someone's before me, that this may be their most important day in court, even though I do it every day, not to forget that, to treat them with courtesy and respect, to do my job based on the facts that I hear before me, and make those decisions in following the law, upholding the Constitution of the United States and of the state of Oklahoma. Thank you all. You got, yeah.
Good evening, I'm Brett Morton. I've been a practicing attorney here for several years. I was born right here in Ardmore, Oklahoma, raised here and educated here. I went to Southeastern Oklahoma State University, pursued a professional pilot's aviation program degree, logged many of hours in an airplane going to small airports all across the country by myself. My wife said, Brett, if you want to marry me, I want a husband that's actually going to be at home, not gone 28 days out of the year. And so I opted for my second career path choice, and that was practice of law, where I can actually use a degree and develop purpose every day to help somebody, and that's what I've done. I went to school, law school at OCU, Oklahoma City University in Oklahoma City, and upon graduation, I worked with a larger firm, and I've represented hundreds upon hundreds of hardworking Oklahomans across the state, Oklahoma City, Tulsa, north, almost up to Kansas, and as far south as Thackerville. And one thing remains the same, is that those people that I've represented, they want somebody that's going to fight hard for them every day, and fight hard for them in the courtroom. And that's what I've done. I've dedicated my career to actual litigation, protecting those people that I represent, protecting their rights. I've been proud to say that I've been able to recoup well over $1 million for my clients. And that's something that I hold dear to my heart, because those people have usually gone through traumatic experiences. Right now, I practice a lot of areas of criminal defense, bankruptcy litigation, also family law. One of my favorite areas of practice is that of adoptions. Adoptions bring the most joy to me because I have two small children, Elizabeth and Cooper. They're ages 4 and 8 as of today. I have a beautiful wife, Erica, and together we've been blessed to have healthy kids. And one thing that brings, again, joy to my heart is seeing a family made whole. For various reasons through the court system, there's been parents out there that fought hard to have kids. And for some reason, natural or otherwise, they're not able to do so. And so therefore, helping somebody actually complete that family unit and taking that picture on the courthouse steps with their new child and celebrating that new birthday is something that rewards me every day and keeps me going. The reason why I want to be your judge is because I think there's an opportunity here in Carter County to make some changes and expand upon some things that I think we're going to get to a little bit later in the questioning. But one thing I think Carter County deserves is somebody that has spent his career fighting hard for his clients, that knows the struggles that it takes to prepare for litigation, to prepare cases through jury trial, and to argue those cases successfully and walk out with them out of the courthouse steps being successful in litigation. I think we need somebody that fully understands that. My career has also encompassed civil litigation that has involved federal laws as well. And so whenever a federal law interacts or contradicts with state law, it's complex litigation that has to be resolved. And I've done that. And that's what we need here in Carter County. We need somebody that has hands-on experience so we can move Carter County forward. On November 4th, I'd appreciate your vote.
Okay, now we'll move into our questions. First question. Okay. If you could change one thing about the court system, what would it be and why?
Escalators. There has to be escalators. One thing I would probably change about the court system, right now the federal court system has online filing, has a lot more online access to records and orders and calendaring and docketing. I think using those current tools and catching up with today's technology, I think would be one thing that would highly benefit us practicing attorneys and help reduce the costs of our clients. And I think changing that would give more open access to the public, so that the public can have open access to their own court system right here in Carter County. It's my understanding their state legislature is looking at doing that. There's a lot of costs involved, and there's a lot of hurdles to overcome, and procedural safeguards have to be in place before that can become effective. But catching up with today's technology and implementing that system properly would be one thing that I would like to see changed.
All right. And I would say that access to the court system is a fundamental thing that needs to be changed in a couple of ways. One, electronically. Last time I was here, I talked to you about the unified case management system that the Supreme Court has implemented. Now, you're going to have to talk to your legislators, however, because they just took $10 million out of the Supreme Court budget to run the Supreme Court, so they had to use the $10 million that they were going to use for the unified case management system to make everything electronic, so that you could just go online, pay a price, and look at a case, see what the pleadings were, read everything. They've changed that. The legislature decided that one of the cases the Supreme Court decided last year having to do with tort reform that they held unconstitutional didn't make them happy, and so they took the $10 million out of the Supreme Court budget. Hopefully that'll happen. But the other axis that I think is just as important is to get people involved in the community and come up to the courthouse and feel comfortable enough to come into the courtroom and see. Now, juvenile hearings that involve children under 18 are closed because for the protection of the children, so they don't have the stigma of having people know who they are in the future, that their maybe parents' rights were terminated, or things of that nature. But almost all our other hearings are open. The problem is, in some cases, on Tuesday mornings, I have a preliminary hearing conference docket. I probably have somewhere between 25 and 40 felons before me. I only have 26 chairs in my courtroom, so seats are limited. But if you ever do come and you want to be at court, I think that access is important. So you can actually see us at work, know what we do, know our temperament, know how we treat people, kind of see us at what we really are. It's one way to really know. If you read it in the paper, sometimes you read the right things. Fortunately, the paper's been coming into the courtroom here recently, and so has the TV. So I think you're getting better information, but there's nothing like being present and sitting in the courtroom. So I'd like to include people into that process.
Okay then, question number 2. Judge Baldwin, you'll be number 1 on this, of course.
Yes, sir.
What in your current position makes you the better choice for a judge?
Well, ultimately, you all are going to have to make that decision. But I believe my experience, I'm 52 years old, I have some varied life experience, I've been a petroleum landman, I've worked in restaurants, I've worked on an asphalt crew during college, been a lawyer for 20 years, I've worked in different areas of the law. I think specifically, however, though, the advantage that I have over candidates that we've had in the races is that I have 5 years experience as the special judge. I've had to do the job for 5 years. It's given me great insight to what you need and how you have to do it. On-the-job training, I would say. The special judge, however, is an appointed position. The district judge appoints the special judge. They serve at their pleasure. I was originally appointed by Judge Walker. Once Judge Morris became the district judge, he allowed me to stay. So I've been the special judge for 5 years now. But I think that's probably the biggest advantage, is that my age, years of service, and experience. Thank you.
As stated earlier, I think the one thing that perhaps gives me a different edge is that hands-on litigation. I've spent my career, again, actually handling cases from start to finish, whether it's before a jury or before a judge. And starting those cases from start to finish, representing those people and going on the emotional roller coasters of highs and lows, and seeing clients at their worst and seeing them on their best day, I think it's prepared me for this job. I know that the service that I've conducted for my clients in front of the bench has prepared me to serve the community behind the bench. I know whenever somebody steps into what would be my courtroom, is that I know the preparation that has gone in. I understand what those clients are experiencing because I've been there with them, tried and true. and understand that that day in court is going to be one of their most important days in their lives, and that the decisions that I make are going to affect their daily walk. And I want to take that seriously. And I think that we need somebody that has been there and has represented these people to serve the people.
Okay, question number 3. How could the cost of judicial administration be reduced? Can you give us a specific example of how you have reduced cost in your court or in your law practice or in the court? And it's for you, Mr. Morton.
Sure. I think there's a lot of factors, to be fair. I think there's a lot of factors that go into that. We're, as judges, we're not the only ones that make those sole decisions of what goes on. There's other elected officials that have a say in that. But what I can say is this. In my own firm, at the firm that I was at prior to being out on my own as a solo practitioner, we've utilized technology to save time and cost for our clients. Technology that instead of traveling for depositions hundreds of miles and having to bill those clients for that, we can do locally and passing those cost savings on to our clients. One thing that I would do as a judge is expand our dockets. We would have more dockets so that things move quicker and move more efficiently. As far as cost savings is concerned, I've discussed the potential online programs, online calendaring that could help save time. But as far as right here in Carter County, each judge has a bailiff and a court reporter, and that's essentially the staff that there is. So there's not a lot of fat to cut, if you want to call it that. So we would look at any possible ways of trimming our overhead so that we can pass those savings on to the taxpayers and not waste their money.
This pause in between speakers is, we're setting the timer again, if anyone's wondering.
We were just thinking. I do it every day. The criminal docket, there are so many constitutional things that have to happen. There's the district attorney, there's a criminal defense lawyer, and there's a constitution that we have to hold. And some things go a little slower than the public would like. Here in Carter County, they go pretty fast still. Where we can really save cost is on the civil side of litigation. Mediation, arbitration. When people get together and make a decision and decide to settle something on their own, specifically a divorce, they're happier. If there's children involved, oh my God, if the parents are happier, the kids are a whole lot happier, which makes me a whole lot happier. And it just makes life easier. If they're happy when they actually decide and settle their case, they don't come back for motions to modify post-decree issues as often. Sometimes it happens, not everybody gets along forever, but mediation is just the key. I send everyone I can to early settlement mediation. It's a program put through the Supreme Court of Oklahoma and East Central University. We have Jaxie Johnson in our courthouse. She does the mediation through volunteer mediators. And we send, I think, 69 cases for divorces last year. They settled 71% of those. That's a minimum of 3 hours in court, 39 cases. It's about a month of court that I would have to do otherwise that's settled. Well, to have people happy at the end of it, because believe me, in divorce, it's really emotional. We see a lot of really wonderful people, sometimes at their worst, just because it's a tough issue for their lives. And so when they can settle it, and we can give them that opportunity, it's huge. We can also do that, and we do it in civil litigation as well. We send them to private mediation or arbitration, and it makes a big difference.
Okay, Judge Baldwin first for question number 4. Do you believe there is such a thing as a victimless crime? If so, what offenses would you place in that category?
Well, my answer is the same that I told you last time. Absolutely not. Every crime has a victim, and it's the taxpayer. Even if it's a law that you don't like, there's a victim, and it's still the taxpayer. Because if law enforcement has to enforce that crime, prosecutors have to prosecute it, defense lawyers have to defend somebody, and it takes up court time and judges have to come into it, there's a huge expense in it. Not liking the law is a different question. That's something you have to talk to your legislature about. But if it's a law, I've sworn a duty to uphold the Constitution of the United States, the state constitution and to follow our law, including statutes, even with someone sometimes crime that you don't like, it has to be to contact the legislator and get it changed so that it's no longer a crime. But if there is a crime, the victims, at least us, if not many other people. Thank you.
Again, as we discussed back in the springtime, every crime can be attenuated to the taxpayers. You can extenuate that down to dollars and cents of time spent, however that may be, court system, law enforcement agency, or otherwise. If your question is actually directly to actual crimes that have victims, physical victims, sure, there are a lot of crimes that don't have actual victims that you can call to a witness stand. But can you extenuate that to a taxpayer? Certainly, sure. It's all basically, I guess, a question of relativity of how far you want to extenuate those impacts.
Okay. All right, question number 5 then. Mr. Morton, what do you think about the growing prison population? What response should society have to prison overcrowding?
Can you repeat that question? I'm sorry.
Yes, sir. What do you think about the growing prison population, and what response should society have to prison overcrowding?
Sure. Well, it's simple. Prisons play a vital role in our society. Prisons are perfect places for certain individuals that roam our streets every day. As far as prison overcrowding is concerned, I guess the easy answer would be bricks and mortar, keep on building. But one of my favorite quotes is that change always starts at the dinner table. And as judges, we can't be there to raise the kids from start to finish. We can't impact the socioeconomic factors that affect their lives, whatever there may be. But at the end of the day, people are going to be held accountable for their own choices and the own decisions that they've made. And so with that being said, as long as there's crimes that are being committed and they are found guilty after exercising all their constitutional rights, well then that's the place for it. There are other sentencing alternatives that the court can employ that could help reduce the overcrowding for nonviolent offenders, people that have never committed a violent offense. There are plenty of alternative programs, such as the drug court program or a mental health court program, that can be extended to those individuals that would help rehabilitate them, to perhaps change their course of life and help them realize that the choices they make are not always the best choices. And so with that being said, the judge has the power, so long as the people meet the eligibility requirements pursuant to statute, to employ those various sentencing options. And so that's one way that we can reduce prison overcrowding. But at the end of the day, it goes back to one thing, and that's personal choice.
Well, as a judge, if I'm following the law, if someone is capable to get a deferred sentence and they qualify for it, and the facts would show that, that's probably what they should get. Now, a deferred sentence would mean that if they got a year's sentence, they wouldn't go to prison, they may not go to jail, and if they do the things that the court has ordered during that time period, they will not be found guilty at the end of it and can expunge their sentence and will only have an arrest on their record. If they get a suspended sentence, that means that you're suspending any time in jail, but they're going to have a conviction on their record at the end of it. If it's a misdemeanor conviction or if it's a felony conviction, felonies can really impact your life forever about employment. But if it's what happens, it's what happens. Prison time, if it's a crime that's violent and they go to prison, that's what a judge has to do. Now, as a society, I can't tell you what my opinion is, because ethically, if I say I'm for building more prisons or I'm against building prisons, I won't be able to do my job in an impartial and fair manner. But I will tell you this: if you want more prisons, you have to contact your legislature. If you don't like a law and you don't think it should be a crime, contact your legislature. The other reason I think access to courts are important, especially about this type of situation, is I can tell you that in Judge Carr's courtroom the other day, a gentleman was sentenced to 8 years for drug charges. He spent about 6 months in Carter County Jail. The deputy that transported him here from Carter County took him to Lark, it's in Lexington, where they get processed into the Department of Corrections for the state of Oklahoma. They said, oh, by the way, if you can just go back to lunch and come back, you can pick him up we're going to have an ankle monitor on him, and you can take him back to town. 6 months, sentence to 8 years, back in our community. That's not the judges. That's the Department of Corrections. Just talk to your legislature.
Okay. Question number 6, Judge Baldwin. Would you favor or oppose a system in which all sentencing decisions were routinely reported in local newspapers, indexed by the name of the judge? Why or why not?
Well, just like I said last time, I'm in favor, if you can get any type of media that wants to do that, that's great, and I'm for it. As a judge, I'm not ashamed of what I do in sentence. It goes back to what I said earlier about access to the courts, kind of coming and watching everything, because when you see everything, what the prosecutor does, what the defense lawyer does, judges can only make decisions based on testimony and evidence presented to them in court. That's what you want us to do. It's part of the law, it's part of the Constitution. You certainly don't want me to sit up there and decide what a crime is, who should be guilty of it, and on an ad hoc basis, just let me be the tyrant. That's not what we need. So, I think all in all, you just got to have access. People get in, know what's going on, because there's more than just what the sentence is behind what happens to somebody. It's what's been said in court. And without that information, you may be missing part of the story. But I'm not ashamed to have any of my rulings published. In fact, if you're willing to pay and be a member of certain CalPro items or certain electronic systems now, you can get on and learn everything I do. It would probably put you to sleep, but you can certainly do it.
He waits for you.
Absolutely. Absolutely. That gives the citizens transparency into the courtroom. I would not ever be ashamed of the decision that I made, because I know in my heart of hearts, as a lawyer upholding the Constitution and as a judge, making sure that those rights are still protected in the courtroom, I would never be ashamed of the decisions I make, because I want to be able to lay my head down at night. Now, there are so many factors, again, that go into that. You can pay $50 a month and have access to CalPro and look at all sorts of things, so long as they're not protected, such as any type of violent sexual offense or juvenile matter that involve children. And you can see what happens. One thing that I would add on to that is not only index it by the judge, but index it by the attorneys that handle that, along with the district attorney that particularly handled that case. Now, one thing that you're not going to find on the current online system, which I think everybody should have access to, is that actual reports, the actual facts, or the alleged facts, according to whatever the situation was. Right now, again, I've handled well over 300 felony cases, start to finish. And each one of those felony cases were required by law to complete a plea of guilty summary facts worksheet. It's about 8 to 10 pages long, and one of the particular questions is that you have to recite the actual facts that went down, so that you would know on a guilty plea the actual facts that happened in that particular case. Same thing with misdemeanor offenses, so long as they're enhanceable. Some courts require that those be written down as well, and there's a record of that, so in case the defendant ever wants to say, you know, my constitutional rights were not upheld in court, or I want to back out of that deal, well, there's a record. Not only is there a court reporter, but there's actually a plea worksheet that people can view. And you can look at that, and you can see with the whole shoot and shaboodle, the whole shebang. You can get the whole story right there. Again, I think a lot of times the cases that are reported through different media outlets may not be the exact truth. But if we have an open system for transparency, that would be great for the citizens of Carter County.
Okay, 2 more questions. Question number 7. Mr. Morton, what do you believe are the causes of the high rates of minority incarceration?
Well, again, going back to my other answer and response, I think it all starts at the dinner table. I know how my parents raised me. I know I come from a good family. I was raised what I believe to be by good morals and values. I think I made good choices. Now, with that being said, why are these people committing crimes? There's a lot of factors that we can sit here and speculate about all night. But one thing it comes down to is personal choice. There's a lot of social economic factors. There's a lot of mental health issues that take place and things that we can't explain here as judges. But what I can say is this, is that we do have an increased population of minority offenders in our prison systems. I think there's various causes for that, and as a sitting judge, one thing that we can do is just uphold the law impartially and give everybody the same fair treatment and respect, regardless of their race, nationality, creed, or color.
Well, there's a whole lot of things that have nothing to do probably with the court system actually that really impact on that. Cultural things, single-family homes, education, upbringing, economics, history of jobs and families and morals, judgment, and yet it does cross not just all racial boundaries, it crosses all economic boundaries. But I'd have to say those types of things. You would have to probably include things about racial profiling over years of history. Now, judges have nothing to do with who's charged or who's arrested or how all those things work out. And so we just have to treat everybody fairly and impartially and decide our cases on the facts before us after hearing the testimony and the evidence. But I do think education has got to be the #1 factor. I was just talking to one of our teachers the other day, and it was a counselor, Stephanie Hacker, at the middle school. She said that in Ardmore, in Carter County, including just all the schools in Ardmore, all the schools in Carter County, it's about a 30% dropout rate once you get between 9th grade and senior, 12th grade in high school. That's horrendous. I mean, that is just horrendous. Those people that don't have the high school education are starting off with a great disability. And then you add on to that single parent home, low economics, not a bright future, the inability to go to school, to work maybe at minimum wage. It's really, really hard. And I think all those things are factors. Thank you.
Okay, question number 8 then. Judge Baldwin, who are your judicial role models and why?
Well, I have 3, actually, primarily. First, at the United States Supreme Court level, I would have to say Antonin Scalia, because of his strict construction application to interpreting the Constitution. And what it does is he just uses plain English language. It means what it says it means. It doesn't take a rocket science to figure out what it means. And he applies that law to those facts, and it ends up in the conclusion where it is. He doesn't start out with the conclusion and then try to apply things to the Constitution in interpretation. It's a strict construction application. Second would be at our Oklahoma Supreme Court is Justice Stephen Taylor, primarily because he, our current Supreme Court Justice in the state of Oklahoma is Tom Colbert, and he's a wonderful guy. Stephen Taylor, however, went to the mat for the judiciary in Oklahoma with the legislature and the governor on several issues. He was actually more frugal than our legislature, and so they kind of left our budget alone while he was the Supreme Court Justice. The reason I admire him so much is because when his secretary moved, he didn't hire one. He answered his own email, he answered his own phone. While we were getting our budgets cut, he cut his own budget, and I think that's pretty impressive. Last is, here locally, Charles Tate, our special judge before me. If you know Judge Tate, you know why I say that. He's just an honorable guy, he's a wonderful person, and I respect him immensely. Thank you.
When looking at the question, one of the first thoughts that came to my mind was thinking back to the United States Supreme Court back in the Earl Warren era. As a judge, it's vital to make an important decision regardless of what the outside pressures may be. Earl Warren decided the case of Brown versus Morton of education, along with the other justices. And what did that do for us? It got rid of discrimination. And listening to my mother talk of a time when she remembers sitting in school in the southeastern states and seeing African Americans for the first time in her school, it really brought it home. It was a completely different world, and I believe everybody is created equal and has the same exact rights, inalienable rights that cannot be taken away simply because of your race or creed or color or nationality. And so thinking back to the Earl Warren era, how difficult of a decision it might have been to actually stand up for the beliefs that everybody's created equal and make that decision possible so that they're affected so many millions of lives throughout. Additionally, thinking back to the Warren Court, we had so many criminal decisions that affected many of our lives today. We have Miranda v. Arizona. We have Matt versus Ohio. We have the Gideon case. The Gideon case that basically says, listen, instead of just getting a lawyer because you're poor in a capital offense where you can be put to death, you can have a lawyer at any stage for the felony offenses or any other offense that you can be incarcerated for. And so I thought that was very important. Additionally, the Griswold case was decided. They basically said, listen, you as citizens, you have rights to privacy. You have rights to privacy. And I think that's something that's very important that holds true with me. Listening to, reading some of the transcripts from those days, I think it's something that really hits home and makes me admire.
Okay, well, we have some time for some questions. Is that okay with you all? Sure. Okay, the way we want to do this is we want to ask a question that both of them could answer, and we want to try to keep everything decently and in order. Ask the question, let them respond. We don't want to get in a back and forth, so one question, one answer. And I guess we'll give the same amount of time that we had before. And, what, we're going to do 1 minute on these questions? Okay, so who has a question they would like to ask? Yes, Shelley.
Can you tell us, from a professional and or a personal perspective, what 3 things do you think would help reduce the crime rate for this area?
Judge Baldwin.
Prayer, active law enforcement, prosecution of the cases to the fullest extent of the law, which we actually have, and I think you're going to see quite a bit here in the future from law enforcement. But those 3 things I think are very important.
To answer that question, the one main answer again is prayer. You need to do that daily for our community. Secondly, we have to start when these kids are young. I've represented so many juvenile children that they have so much chance, so much promise, but due to the influences in their lives, they make poor choices, they make stupid choices, and those choices continue to haunt them. And so I think if our schools, education programs, other church outlets provide different choices here in our community, different choices than going to the bars, shooting guns at people, and other drug-related crimes. I think we give the kids choices to make. I think they could help guide them. But secondly is accountability, or I guess thirdly rather, is accountability. If people know that by the choices they make, they're going to be held accountable for it, and not just be turned back out to mama or turned back out on the streets, then I think that's going to hit home.
Okay, second question.
If someone is going to make a plea, accept a plea bargain, is the time, I know so many of them are on the docket, they get up to the last minute, and that is time consuming, it's taxpayers' money paying for that, they get up to the last second, we've got a plea bargain, this is it. Is the time that they have to plead on a case, is it statute? Is there a statute that says they can take up our taxpayer dollars to wait till the last second and have our docket full. And we've got people that need to be in court that aren't getting in court because of stuff like this. It's extremely time consuming. If anyone's ever sat through the court system and you sit there and sit there and sit there, and you'll have 5 or 6 of them or more come up the last minute and they've worked out a plea, and it doesn't matter whether it's criminal or civil. They can work out a civil case in agreement at the last second.
My turn first? Okay. Ma'am, to address your question, let's talk about the civil part first because they're two different worlds. In a civil case, if the case is set for jury trial, the judge has already issued a scheduling order. That scheduling order sets the pace and time frame for when things are going to happen, okay? Things are going to happen for discovery cutoffs, things are going to happen for settlement conferences, so on and so forth. Now, a lot of times what happens is if we're going to a jury, chances are we're going to get all or nothing. And so, as an attorney, sometimes my clients say, I don't want to take that risk. And so it's better to settle out of court because of the rights you may compromise during a jury trial or the outcomes, possible outcomes. And so to answer that question, that's why a lot of cases so many times settle, is because finally people are pushed to the brink of a decision point and they'd rather take the safest way out than risk it to a jury. And I understand your frustration with that. Criminal cases are a different breed. Criminal cases, there's no specific statute that will actually dictate that amount of time. I'd love to expand on that.
Let's give them
It's
2
too-
minutes for these. Give them another
Finish
minute.
your thought there.
Yeah.
Anyway.
Finish your thought.
In a criminal case, there's not a specific statute that addresses that. But a lot of times what happens is so many different variables. From the state standpoint, that witness that was so gung-ho about prosecuting, guess what? We can't find him or her now because they've hit the road and they don't want to prosecute or stand up. Now, as far as, and so therefore it leaves no other option about that, but to either negotiate a plea deal or proceed on to a jury and risk an outcome that the district attorney perhaps would not want, okay? And I understand that, I'm just trying to explain it to you. Okay, so now in a criminal case, is that working?
No, we're just letting you
gonna
finish.
give
Okay.
a few more seconds to wrap it up.
Sorry. In a particular criminal case, a court will set the time limits and time constraints of when a negotiated plea will be accepted. Now, there are certain times that, for certain reasons, that a negotiated plea will be accepted right up in time for a jury trial. And so to answer your question in short, there's not a set specific time, statutory period of time in which a plea has to be accepted. There's constitutional requirements that have to be met first, and once those are met, then the court is free to set a timetable on those. I wish I could have a lot more time to answer the question, but in short, no ma'am, there's not. A court can refuse a negotiated plea or refuse to accept a plea and force the parties to trial.
Judge Baldwin, if you'd like to take a little extra time. You may.
Okay. Well, coming to a felony trial docket is kind of like watching sausage made. It's pretty ugly. The last docket, we had 60 cases set on the trial docket. Only, I think, 3 cases actually went to trial. 2 civil cases and 3. Here's the thing. When someone pleads, and it's a negotiated plea, they have a time frame. The judges all have it on their docket. If you get to the docket call and you announce jury trial, generally from that time forward, 99% of the time, a judge is not going to take a negotiated plea. That's a plea that the district attorney and the defense lawyer would agree to. After that, it'll be a blind plea in which the defendant stands up before the judge and says, I plead guilty. Then the judge says, okay, I'm going to accept your plea, but to find out what the basis of fact, what did you do? If they won't say, I did it, or won't admit to it, the judge will decline the plea and put them back on the trial docket. It's like many things in life. Many defendants, if we had 60 set and only 2 criminal trials go, and everybody else pleads at the end, even if it's a blind plea, it's the pressure at looking at 12 people sitting in a jury box, knowing that they're there, getting ready to potentially sentence them maybe to a maximum crime. While it's ugly and while it costs us a lot to get there, they have a constitutional right to everything along the step of that process up to trial. However, the blind plea, the reason it's necessary is it saves the expense of trial. If we, at that point, at the docket call said everybody had to go to trial, we couldn't afford the jurors in this county to try all the cases that we'd have to try. The expense would be great. There is a huge cost saving. It's just very frustrating to get there.
Okay, how about another question? Jason, go ahead.
As a foster parent of 2 little kids, just talk about the things you do in your court to take care of the ones that can't take care of themselves.
All right, Judge Baldwin?
Well, ethics rules prevent us from saying we're for children and we do things. Now, we follow the law is what we have to do as a judge. Now, I've been a lawyer for 20 years. I've represented children who were appointed in deprived cases and represented them for 14 years. I know the exact process. All of that with the Department of Human Services in deprived cases is controlled by the law. There's a district attorney trying the case. Department of Human Services is involved. There's lawyers appointed to each parent and to the children. There's a CASA worker. All those people bring forth facts for the judge to make those decisions. The burden of proof in that area is the best interest of the child. So as a judge, you always hope that when you're using these facts to make these decisions, that you're relying on accurate facts that have been presented to you, and then you try to make that decision based on the law, which is the best interest of the child.
To answer your question directly, as a judge, I'd be in control of my docket, the timeline of which I have control over. There's Title 10, Title 10A, they control the actual statutory periods of time. But what we have in most of those cases is where a district attorney is not doing his or her job, perhaps, if things aren't moving quick enough. I've represented several children. I've represented several foster parents and adoptive parents. And one thing that is all too true, is very frustrating, is that the time that's gone by. In order for adoptive parents to move forward, there obviously has to be a termination of parental rights. Okay? In the state of Oklahoma, the law requires that once a disposition hearing has been held and there's a disposition order in place that gives parents of deprived children 90 days to correct the conditions in which led to the adjudication of their children being deprived. After the point of that 90 days, then the court, rather the district attorney, can look at filing applications to terminate the parental rights or extending that period of time based upon several factors. A CASA worker, who is normally appointed in those types of cases, a DHS caseworker who is in charge of that particular case and works closely with the district attorney, and the evidence that's been presented to the court. And while it's not the court's job to terminate a parent's rights based upon a set timeline, that's more in line with the district attorney. And the district attorney is in charge of prosecuting those cases. Now, one thing that Oklahoma statutes do allow is it allows the court to appoint an attorney for the children, which I think is very beneficial, because a lot of times these kids don't have voices in the courtroom. But we're very fortunate that in our county in particular, lawyers are appointed to act on behalf of the kids. And right now, a child's attorney, thank you for the music, a child's attorney can move on his or her own volition to terminate the rights if he or she feels that the case is not moving in a direction that's in the best interest of the child. And then that would be up to a jury and or a judge to decide that case based upon solely upon the merits of the case. Thank you again for the cue.
Sorry about that.
I don't know how I did that.
One
Good.
more and then we'll send it.
Okay, we have time for one more question if somebody has one. Anybody at all? One more question. Going once? No more? Okay, well, we have designated for the end then for each to have 2 minutes for closing remarks. And I've gotten lost in all of it. It'll be you, I guess, now, since you just spoke. I believe it'll be you, and then we'll close out with Mr. Baldwin. Is that correct? Okay.
Folks, thank you so much for your time tonight. On November 4th, you're going to make a decision. You're going to pick your elected judge, your associate district judge here of Carter County. I urge you to vote for me, to vote for Brett Morton on November 4th. Folks, I believe that I had the experience that it takes. I had the hands-on litigation experience. I've represented hundreds of people here in southern Oklahoma. I know what it's like to be at those council tables and try a case, start to finish. I know the highs and lows. I know the roller coaster that these people are on. I know that whenever they get home, all the circumstances have changed. And it's not just what's been presented to a judge, but there's a whole backstory that the judge doesn't get to hear. And I know what those people are experiencing. I think I'm the best fit for the job. I will be fair, I'm impartial, and I think that my core values suit me to serve the people of Carter County. And together we can move it forward. We can exercise those different sentencing options and expand our drug court program to reduce the burden on the taxpayers. We can do so many different things. We can get the community involved. We can have more open access to the courts, because I would invite that. Folks, it's your decision. So on November 4th, I again ask you for your vote. Thank you.
Well, I believe that I have benefited from my 5 years as the special judge, being in court. I think that my 20 years of experience as an attorney and being 52 years old with other life experiences have given me a good perspective in life. God willing, that's turned into wisdom. I'm not always right, and I know that even when I make decisions in court. In those cases, all you can do is pray that you do the right thing and hope that it comes back before you so that you can correct it if you can. But I just ask that if you will elect me, I can give you my word that I promise that I will be fair and impartial to the people that appear before me, that I will follow the law, I'll uphold both the United States and the state of Oklahoma Constitution, and I'll make you proud of me. And I'd appreciate your vote. Thank you.